So in this video, I have an update for you on the Texas Suppressor Freedom case, which aims to stop the NFA and ATF's regulation of suppressors. The 5th Circuit Court of Appeals will now hear this case in just 2 weeks, so we need to talk about what is happening. As I mentioned in the intro, in this video, we're going to be discussing the Texas Suppressor Freedom case, which aims to eliminate the NFA and ATF's regulation of suppressors. The ATF is now trying to get this case thrown out of the 5th Circuit by arguing that any positive decision in this case will cause the improper circumvention of people paying a required NFA tax. This case we're going to be discussing is called Paxton versus Debach. The ATF is trying to argue that the NFA's tax requirement bars this case from proceeding forward in the 5th Circuit, and also that the 5th Circuit should agree with what the lower court said in their dismissal. And now all of this is coming to a head with oral arguments. They're going to be taking place in just a couple weeks, in just 2 weeks actually, in the 5th Circuit on May 1st. That means that the 5th Circuit will decide whether or not the Texas Suppressor Freedom case, this Texas law in place, was properly thrown out, or if the suppressor case should in fact proceed forward. The ATF recently submitted their briefs arguing that the 5th Circuit should uphold the dismissal of the case below, and ultimately even argued that the 5th Circuit did not need to hear this case at all. However, the 5th Circuit Court of Appeals, the 3-judge panel there, rejected that argument, and now this case, in fact, is going to be heard. In their brief, the ATF once again argues that as accessories, suppressors are not bearable arms protected by the Second Amendment. The ATF also argues that the required NFA tax makes this lawsuit invalid. But the plaintiffs just exposed those arguments by pointing out that this whole tax issue is 100% irrelevant. The 5th Circuit here does not need to consider this NFA tax requirement or the AIA for this case to proceed forward. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 aims to exempt from federal regulation all suppressors that are made in and remain within Texas. The claim behind this law is that since these items are made in and sold exclusively within the state of Texas, they do not fall under interstate commerce and therefore fall outside the purview of federal regulation by the ATF. Now, after Texas passed this law, the ATF sent out a warning letter threatening pretty much everyone in Texas that the ATF will enforce the NFA and GCA's regulation against made in Texas suppressors. So again, be very cautious dealing with this. Do not engage in this type of conduct because the ATF is still enforcing the NFA against made in Texas suppressors. You can get yourself in a lot of trouble and you're going to want to wait for this lawsuit to play out. Now, in response to what the ATF's position was and in response to this new law, the state of Texas then filed a lawsuit suing the federal government. And then this case was eventually submitted to the federal district court there on cross motions for summary judgment. Now, after reviewing this case, the district court judge there granted the motion in favor of the federal government. The court ruled in favor of the federal government under the rationale that the plaintiffs here lack standing to bring this lawsuit. On review, the judge found that the plaintiffs have not suffered an injury in fact, and therefore they had no standing. Here, the judge essentially stated that the individual plaintiffs would have to allege that they either possess an illegal silencer or that they have engaged in some other prohibited conduct that the ATF claims is illegal. The court also claimed that the plaintiffs maybe could show standing through some sort of evidence that maybe they were directly threatened by the ATF. The judge also stated in his opinion that alleging that the law is unconstitutional just generally because it impacts the Second Amendment and your right to keep and bear arms was not enough to remove the burden of establishing standing. Now, the judge said that maybe there would be a way to cure this issue by going through the NFA forms, going through the process, and then maybe either if you're denied or accepted, well, at least you went through the process and then you would have standing. Finally, the lower court also found that the state of Texas itself did not have standing to sue on behalf of their residents. And based on all that, the judge granted the federal government's motion for summary judgment, and the case was dismissed and thrown out, and the ATF won at the lower court level. Now, in response, Texas filed an appeal up to the 5th Circuit Court of Appeals. The ATF responded to that appeal and argued that the 5th Circuit should essentially affirm what the lower court did, affirm that dismissal, and in fact that the 5th Circuit should not even hold oral arguments in this case. The ATF argued that under the Tax Anti-Injunction Act, or the AIA, this lawsuit was improper since it would result in the avoidance of paying the required NFA tax requirement, the NFA tax under the statutory language. The ATF claims that the AIA prevents something like this from happening. They claim that under the AIA, there's a specific process to these types of challenges, and that the plaintiffs here would have to go through that process, but they cannot file these types of lawsuits because it would result in maybe an injunction or some sort of decision which would avoid paying a required tax. Also, initially in this lawsuit, when it was filed and at the lower court level, the ATF claimed that the whole process to get the NFA required tax stamp and to register the suppressor and all that it wasn't so burdensome to actually cause an injury. Now, back then they were arguing that it only took about 70 days. A lot of you were saying that the process took a lot longer. Now, recently, we've seen that the ATF response times have gone down significantly. Some people even reporting just 1 or 2 days or just a few days, which is pretty shocking. I don't know if that was in response to this lawsuit or some other things that have happened, but the ATF has drastically changed the response time. Now, whether or not that is going to be something that lasts for a long time or if that's just some sort of weird glitch or something that's happening right now, we don't know. But yeah, the response times for some of these suppressor registrations and tax stamps and all that have come down quite significantly. And maybe even the ATF is going to try to use that to their benefit in this specific lawsuit when they hold oral arguments in just a couple weeks. Then the ATF argued that the Second Amendment is not implicated at all when it comes to suppressors. They state that the Second Amendment's protection extends only to the instruments that constitute bearable arms and that are typically possessed by law-abiding citizens for lawful purposes. Because the Second Amendment covers only bearable arms, laws that regulate firearms accessories or attachments do not necessarily implicate its protections. And a silencer, according to the ATF, is a firearm accessory. It's not a weapon in itself. The ATF's two main arguments for why this case should be thrown out and why the Fifth Circuit should uphold what the lower court said is first that this involves an NFA tax, and the NFA's tax requirement implicates the AIA, and therefore this lawsuit is invalid. And also, they continue to double down on the whole argument that suppressors are just simply accessories, and therefore they're not afforded protections by the Second Amendment, and the Second Amendment is not implicated in this case. Now, in response, Texas filed their brief, and they went after all these arguments of the ATF. First, Texas points out that the whole tax issue is not even at issue in this case and on appeal. Texas argues in their brief that that issue is not before the court. The district court did not rule on the Tax Anti-Injunction Act or even acknowledge the issue in its order of dismissal. Instead, it decided only standing and only the injury in fact prong. The court should not consider the parties' Anti-Injunction Act arguments. The district court should consider them on remand. What Texas is pointing out here is that this appeal is just about standing. The lower court dismissed the case because they believed the plaintiffs, the individual plaintiffs in Texas, lacked standing to bring this lawsuit. The main basis for that was that the court said neither the parties nor the state of Texas, had an injury in fact to meet the standing requirement. The court did not consider the AIA. So the ATF throwing that in now is pretty much irrelevant and should not be considered. And then Texas points out why they do in fact have standing to bring this lawsuit. Texas points out that because of the Supreme Court's recent 6-3 decision in the New York State Rifle and Pistol Association versus Bruin case, which struck down New York's concealed carry processing scheme, Texas and the plaintiffs here do have standing to challenge this NFA process. They argue that post-Bruin, whether citizens may challenge requirements to apply for permission to exercise Second Amendment rights is an open question. Although the ATF cites these opinions as controlling authority for this court, it saves this argument for last and surely because it recognizes the shaky status of these opinions post-Bruin. Here, what the ATF is directly using is the Bruin decision to point out that this whole post-Bruin world, they have the ability to challenge application processes, and that includes the application process under the NFA to get a suppressor and to lawfully possess a suppressor. The whole process can be challenged using the Bruin precedent, and that's exactly what they are doing, and that's exactly what they did here in this lawsuit. And therefore, for the lower court to say there is a lack of standing is simply just not correct and violates what the Supreme Court said in Bruin. Now, as I mentioned, the ATF wanted the Fifth Circuit to not even review this case, to not hold oral arguments in this case, and to simply just agree with the lower court and dismiss this lawsuit. But the Fifth Circuit has rejected that position. Oral arguments will in fact happen in just 2 weeks. This case will be heard in front of the Fifth Circuit. The hearing will take place on Wednesday, May 1st at 9:30 in the New Orleans federal courtroom. Something we are going to be watching for in just 2 short weeks. A significant case is going to be in front of the Fifth Circuit again, dealing directly with suppressors, and this case challenging the Made in Texas suppressor law. So again, as we get more information, as things change, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.